obtain before the court can entertain a confiscation inquiry, a forfeiture inquiry. However, in the context of Chapter 5, the court can entertain the inquiry and make a confiscation order even if a restraint order has not been obtained. So that's a crucial difference between Chapter 5 and Chapter 6. You can only launch a Chapter 6 forfeiture application if the asset has been secured, restrained, or preserved, whereas in Chapter 5, a Section 18 application, there is no need. It's up to the prosecution to actually decide whether or not to secure a restraint application to secure the assets, but it's not a necessary requirement. A restraint order can even be obtained after the court has issued a Section 18 confiscation. So it's important to maintain those distinctions. And I think it'll become clear as we work through the key provisions why that is the case. Essentially, Chapter 6 proceedings is concerned with the assets, not with the owner of the asset or the accused person or the person who committed the offense, but a legal fiction is employed that renders the asset virtually as the accused person. So often you will have seen in forfeiture proceedings, the accused is cited as the item of property. So it's NDPP versus ERF 123 Waterkloof or an Isuzu Bakkie with registration number XYZ. So the actual asset is identified as the accused, and the proceeding is about, so just like in bail proceedings for the purposes of a criminal trial, you'd have to secure the attendance of the accused at court, either through arrest and through bail proceedings. There has to be an inquiry that will ensure that once the trial commences, the accused will be available, and once judgment is handed down, the judgment will be given effect to. Similarly, Chapter 6, the property is seen as the accused person, and therefore the property has to be secured in court. Whereas in Chapter 5, what the court is essentially handing down in a Chapter 5, Section 18 order is a money judgment. It's judgment for the accused to pay a sum of money. And once that judgment has been issued, it has the effect of a civil judgment, which can be used, which can be executed against any property held by the accused. But we'll work through these concepts a bit more as we go along. So what we aim to do is answer some of the following questions, and I've already started by talking about essentially what is a Chapter 5 proceeding as opposed to Chapter 6. In other words, Chapter 5 being conviction-based and Chapter 6 being non-conviction-based. In South Africa, we also talk about Chapter 5 being criminal forfeiture and Chapter 6 being civil forfeiture. The reason why I prefer not to use that distinction is because even Chapter 5 proceedings, which are connected to a criminal case, is a civil proceeding, because the rules of civil procedure apply to those applications as much as they do in Chapter 6. So I prefer to use, to characterize Chapter 5 as conviction-based, because the conviction is a sine qua non for the proceeding, and Chapter 6 is non-conviction based because you don't have to prove the involvement of the accused in the crime beyond reasonable doubt. You prove that the property was involved in the crime on a balance of probability. We'll look briefly now at what is a Section 18 application as opposed to a Section 18 inquiry. when is such an application launched, what is a confiscation order, what is declared forfeited, what does it mean that these proceedings are civil, who is the defendant, who is the respondent, when has a person benefited from unlawful activities, because that's the essence of the inquiry. Whether the person has benefited and what is the value of that benefit is essentially what the court is concerned with in a Section 18 inquiry. Which offense?
I got it right.
No, it's fine.
Why it stopped now?
Can we ask Tom Khanyago maybe to mute as well? And then we can proceed.
Okay, thank you, Almut. Thank you.
And then we will look at what happens in scenarios where the benefit of the crime was recovered, as well as situations where the benefit is lost. What if the benefit was not retained or was passed on? Is this additional punishment? And what affidavits, papers need to be filed to launch an application? So as I said earlier, there's been considerable jurisprudence already generated in the Constitutional Court, because in the early days of asset forfeiture, every application we launched was attacked on the basis of a lack of constitutional validity. In one of those early cases, in fact, I think it was one of the very first cases, NDPP versus Yasin Mak Mohammed and others, the 2002 case, the court said what Chapter 5 and Chapter 6 in essence are, they represent the culmination of a protracted process of law reform, which has sought to give effect to South Africa's international obligation to ensure that criminals do not benefit from crimes. The Act uses two mechanisms to achieve this, Chapter 5 and Chapter 6. So, sorry, I'm just going to close this so that, oh dear. Can you still see the presentation?
Yes.
Okay, good, because I closed. The Sheikh judgment, which I'll also come to in a minute, both these judgments essentially stated the constitutional purpose behind Section 18 non-conviction based and conviction-based asset recovery as being provisions directed at stripping criminals of the economic benefits of crime. So it's really important to be very clear that the purpose of confiscation proceedings right.
Now Nonyane must mute.
Thank you. I was just trying to find right. So Chapter 5 of POCA concerns benefits derived from an offense. And benefit is the most crucial concept here, because as I just indicated, the whole purpose of Chapter 5 proceedings is to strip criminals from the economic benefit from crime. So it's very important to understand what constitutes a benefit. So which benefits do we focus on in Chapter 5 proceedings? But just to restate, while we are concerned with the benefit derived from crime, as opposed to Chapter 6, Chapter 5 does not actually require that we should still be able to locate the benefit. So for example, if I steal R1 million from a bank, for purposes of Chapter 5, whether I still have the R1 million in my possession or not is not a relevant consideration. It is a relevant consideration in Chapter 6, where you actually have to seize and bring before court the R1 million that is believed to be the proceeds of the crime, or the product or the benefit derived from the crime. In Chapter 5, we ask the court to make a money judgment. We attempt to identify what is the benefit that was derived from the offense, and we ask the court to make an order, or the court makes an order equivalent to the value of the benefit derived. It is a critical distinction between the two proceedings to understand. So as the slide says, what the court does is order an amount of money to be confiscated to the state. And with that money judgment, the prosecution can then go and realize or execute against any property that the defendant may hold. The court is not ordering specific property to be forfeited to the state. That is what happens in Chapter 6 proceedings. That does not happen in Chapter 5. The decision in Rebutsi, which is an SCA decision, Nugent J. held as follows: a confiscation order does not purport to authorize the confiscation of a particular property of the defendant. It is no more than an order upon the defendant to pay to the state a specified sum of money. So in other words, if there's a benefit of R1 million derived from a crime, in fact, in the Rebutsi case, an employee stole money from her employer. But the employee also had a gambling problem. And so much of the money that she stole went in to feed her gambling habit. And an application was brought saying, well, the accused no longer has any of this property available, so a confiscation order is not competent. And the court in...
I've actually just joined it to show that I joined, because then I'll get all the notes.
That's very good. I'll send the notes. So a confiscation order does not purport to authorize the confiscation of a particular property. So the court in Rebutsi says, even though we could identify how much money the employee stole from her employer, the fact that she does not have, or the state could not prove that money in her bank account, for example, is the proceed of that particular offense, the court said it's sufficient for the state to prove that she derived the benefit. Once the court makes a confiscation order, it will then be up to the prosecution to go and locate the asset. In fact, Rebutsi went one step further, because the state in that case decided to bring a restraint application against a property owned by the accused. And the accused in that case could in fact prove that that property was inherited by her from her mother, who had passed on. And she therefore insisted that this was not proceeds of crime, the property that the state sought to restrain. The matter made its way to the SCA, and the SCA said a Section 18 inquiry is not concerned with particular property. It's an inquiry into what was the benefit that she derived, And then once a determination is made of what is the benefit and what is the value of that benefit, and the court makes a confiscation order, that order can be executed against any property, whether it was legitimately obtained property or not. And the reason why it's critical to appreciate that distinction is because the definition of benefit includes proceeds of crime. And most accused persons will say, well, that is not, that the property I own today is legitimately acquired property. It's not for the state to show that any asset is legitimate or not legitimate. It's for the state to show that you did derive a benefit. And the way the Constitutional Court has dealt with this issue as well is to say that why should a criminal who steals from her employer and chooses to take that money that she steals from her employer and to squander it on gambling or wine, women, and song, when she has legitimately acquired property, which she doesn't touch. So she made the election. Her estate was enriched, both by the property her mother left her and by the proceeds of crime that she stole from her employer. Why should she be allowed to choose to spend the money she stole and therefore it's not available for recovery, but she doesn't touch the assets? So the inquiry is, to what extent was her estate enriched? And if it's R1 million she stole from her employer, then her estate was enriched by R1 million. It's not relevant that she then squandered assets on various things. She was enriched by R1 million, and the state is allowed to recover R1 million from her legitimately acquired assets, just like a civil litigant who suffers damages. In other words, in this case, if the employer had chosen to sue her for the theft of the employer's property, the employer would be given a money judgment and could go and execute against her legitimately acquired assets. So there's no difference between such an order and a civil judgment sounding in money and a confiscation order. I've belabored that point quite a bit, but I think it's really at the heart of what Section 18 inquiries are about. And you know, there have been a number of cases that have made the point that these judgments are not about condemning a particular asset and saying that asset is the proceed or instrument of crime. That is what Chapter 6 inquiries are about. Here, it's to what extent was the estate of the accused person enriched by crime, by the criminal activity for which they're being convicted of. So here we are at the applicable section. Confiscation orders are dealt with in Section 18 to 24 of the Prevention of Organized Crime Act. And I think it's worth just pausing here and reading it in full because it's essentially all captured in this section. So it starts with whenever a defendant is convicted. Now, defendant is unusual language in our legal system because we talk about accused persons and defendants and respondents are generally parties in civil proceedings. So it's curious for us to be talking about whenever a defendant is convicted of an offense, because we would normally say an accused person, but for purposes of Section 18, because it's the proceeding is about making an order for the defendant to pay a sum of money. For the purposes of a Section 18 inquiry, the party is called a defendant. A prerequisite for a Section 18 inquiry is the conviction of the defendant. And it's the conviction of a defendant of an offense. And then it says the court convicting the defendant may, on the application of the public prosecutor, inquire into any benefit which the defendant may have derived from the following sets of circumstances. But I just want to pause and indicate what we've already discussed so far. It is the court convicting the defendant that conducts the inquiry, and the inquiry that is being conducted is concerned with what benefit did the defendant derive. And it's not just what benefit the defendant arrived from the offense the defendant was convicted. So, for example, you have a drug dealer being convicted of one sale of or one delivery of a shipment of drugs, and they're convicted. And in fact, at that point, the drugs are seized. The Section 18 allows the court to inquire beyond just the benefit derived from the convicted offense, and says the court may also have regard to any other offense of which the defendant has been convicted at the same trial, and any criminal activity, more importantly, which the court finds to be sufficiently related to these offenses. So if the accused has been charged or implicated in other criminal activity, so in other acts of drug dealing, the court may have regard to benefits derived from other criminal activity. And we'll come back to what those circumstances are. But what the court has to do, the court has to define that the defendant has benefited. So the first question is, has the defendant benefited from the offense? Because if there has been no benefit whatsoever, there is no basis for a confiscation inquiry to proceed, and there's certainly no basis for a confiscation order to be made. So the question of benefit is critical. So it's not appropriate to have a confiscation inquiry if the accused is being convicted of, let's say, rape or murder, if there is no additional allegation that it was done for purposes of deriving a financial or an economic benefit from that crime. So this section is strictly for cases where the crime was committed for the purpose of deriving a benefit. Only once that hurdle is cleared, so the court finds, yes, there has been a benefit, the court then needs to make a determination, what was the value of that benefit? And then, and these are the important words that I think is responsible for the bulk of the controversy around these kinds of sections, is in addition to any punishment which the court may impose in respect of the offense, the court may make an order against the defendant, for the payment to the state of any amount it considers appropriate, and the court may make any further orders as it may deem fit to ensure the effectiveness and fairness of that order. So you'll notice from that the court is given a discretion, a very important discretion, to make a confiscation order that it deems fit. Yeah, so I think there are a couple of things we need to look at here. The first issue is this issue of punishment. It is in addition to any punishment. I'm just trying to find, yeah. Initially, there was a lot of concern around sort of double jeopardy or double exposure to punishment, because the accused is sentenced to a period of imprisonment, and then in addition there'll be the value of the benefits declared forfeit to the state. And I often do training around confiscation, and I was in Kenya recently training a number of anti-corruption workers from a whole range of sectors. And I posed this question. I said, if an accused person robs a bank and they go into the bank, they demand money using a weapon, and they come outside of the bank and they are apprehended, and the R1 million in the bags as they were given it are removed from them. If the R1 million is taken by the police and returned to the bank, has the person derived a benefit from the offense that they have committed? But more importantly, when you remove the R1 million, would you say that the accused has been punished for the offense? To my horror, most people said yes, they think that the accused had been punished if you take away the R1 million. And then when I said, so are you saying you would not impose any further conviction and sentence in those circumstances? And then, of course, quite a few people retracted and said, of course, they would still find the accused guilty of robbing the bank, but they would decline to make a confiscation order. And I think that goes to the heart of the inquiry that the court is asked to perform here. The court is asked to consider, and I think here it's opportune for us to go back to the very beginning and remind ourselves what the purpose of these provisions are. So in Muhammad and in Sheikh, the court said, this is about directing, about stripping criminals of the economic benefits of crime. This is about ensuring that crime doesn't pay. It's not about punishment, because that remains the job of, presiding officers do this day in and day out in criminal courts. They look at the seriousness of the crime and they make a determination and they impose a sentence. What what section 18 is clear about is that this inquiry is a separate business from determining an appropriate sentence. And the one technically should not impact on the other because they're dealing with two different things. The purpose of confiscation is not to punish. The purpose of confiscation is to remove the benefits, to put the accused back in the position the accused would have been in but for committing this crime. The purpose of sentencing is to find an appropriate punishment for the commission of the offense. And I think often people struggle with these different concepts. And so just to confirm, in NDPP versus Phillips, the court was very clear. Confiscation constitutes punishment only if its purpose is to punish the defendant for his crime. But that is not the purpose of a confiscation order. Its purpose is to deprive him of the ill-gotten gains of his criminal conduct. That much is clear from chapter 5. It gets complicated though, when, as in the Rabutsi case I described to you a few minutes ago, where the accused steals the money and then squanders the money. It's important to bear in mind that the decision to squander the money on gambling is not a discussion relevant to whether or not that person benefited, because but for the crime and for the money stolen from the employee, she would not have had that money available to gamble, and she would have had to use her own property, including the house that her mother left her. She would have had to sell that and use that money to gamble. So it's not saying that if you lose the money, a confiscation can't be made and that confiscation order can't be executed against legitimately acquired property. It's simply saying that you can't try to recover more than the value of the benefit, because that would be punishment. It would be exceeding the bounds of putting the defendant back in the position they would have been in but for the crime. So the job of the presiding officer is to be carefully considering, was there a benefit from this crime, a financial benefit, an economic benefit from the crime? And if so, let's look into the value of that benefit and make an order for the confiscation of that benefit. The next question for the prosecution to answer is, will there be assets to go and execute that judgment against? But that is not a concern for the presiding officer making a confiscation order and for a presiding officer deciding what should be the value of that benefit. And in that determination of deciding what is the value of the benefit, the presiding officer needs to have in mind what is the purpose of confiscation? And the purpose of confiscation is to ensure that crime does not pay. So it could end up feeling penal. And I leave you with an example from a case that shows up the difficult issues that could arise. In the Hubert case, the accused person was the victim himself of a 419 scam. But what he had decided to do is, instead of handing over his own money to the 419 scammers, and he didn't know at the time they were just 419 scammers, or they were people trying to defraud him, he decided to take money from his employer. He was a bank manager, and he decided to use his employer's money to give to an intrepid Nigerian businessman, or alleged businessman, who said that if he released a percentage of the money, he could go to Nigeria and extract many millions more, and you would share back with him the spoils of what they were able to uncover, the typical scam. Of course, he handed over, I think, about 8 million of his employer's money, hoping that they would come back and restore about 20 million, and he could quietly return the 8 million to his employer and pocket the rest. Of course, what happened is the people he was handing the money over to disappeared and were never seen again. And the NPA decided to bring an application for the recovery of the 8 million. And Hubert's argument was, but I never derived a benefit from the commission of this offense. And he was referred to the definition of benefit, which is any service, advantage, benefit, or reward received or derived or retained directly or indirectly. And the argument was, if he wanted to engage in this this activity with these so-called Nigerian businessmen, he should have found his own 8 million. He did not have the authority of his employer to use his employer's 8 million in this scheme. When he took the 8 million, when he took control of the 8 million of his employer's money, in that moment, he derived a benefit of 8 million. Just like the employee in the Robutsi case, once the benefit is derived, she elected to gamble. In Hubert's case, he elected to hand it over to Nigerian conmen in the end. In both cases, they derived a benefit from the offense. And so that requirement is met. What was the value of the benefit that the court should recover from him? Well, the Section 26 does impose a limit. It says the court can't order the recovery beyond, in a Section 26 inquiry, beyond what he still has, because then we are venturing into the realm of punishment. But as I said, in Section 18 inquiries, the inquiry is limited to, was there a benefit and what is an appropriate value? And in the exercise of that discretion, it's up to a presiding officer to decide what amount ought to be recoverable. And because I want us to open up for questions, I want to just conclude on how the benefit inquiry is conducted, and then open for us to have a bit of a discussion on some of the issues that arise in these inquiries. So as I said, the inquiry is essentially what was the benefit, was there a benefit, and what is the value of the benefit? And as I said, it can get complicated because you can also look into benefit derived from related criminal activities, and that phrase has also been considered by the courts. And then there are also presumptions in Section 22 of the Act to say, in essence, those presumptions relate to if you have unexplained income, a presumption will kick in as to it being from the benefits from the proceeds of crime, and the defense, the defendant has the burden to rebut the presumption. As I said, benefit is defined. A person has benefited from unlawful activities if he or she has at any time, whether before or after the commencement of this act, received or retained. So, you know, you've benefited when you receive the money, but you don't have to retain it because it's received or retained. So you could also have received it and then passed it on to somebody else. Any proceeds of unlawful activities, and then of course we have to go back to the definition of proceeds, but the courts have said that if the benefit is lost, passed on or recovered is not the end of the matter. The issue is not what sticks, but what passes through the defendant's hands. So in the Kiriakou case, the accused was convicted of receipts of stolen property. And in this case, a lot of the stolen property was recovered by the police. And the question was, well, if the police recovered the stolen property, did he still benefit? And the court answered in the affirmative because there was evidence of him conducting this stolen receipt of stolen goods in a concerted manner, in an organized fashion. And so there would be room to apply the presumption saying, if he has income that he can't justify from legitimate sources, the court can take into account the presumption that it's the proceeds of crime. In Rabutsi's case, the benefit was spent. The question is, as long as the defendant had it at some point, the Hubert case, even if the benefit is not actually physically held, but the accused became entitled to exercise control over it. That's sufficient. And in the Sheikh case, the courts held even indirect benefit is sufficient. I've asked that we circulate the Sheikh judgment because it really is the seminal decision on dealing with Section 18 inquiries, and because we may run out of time, but the definition of proceeds of unlawful activities the court has held includes benefits received directly or indirectly, which in its ordinary meaning includes benefits indirectly obtained through another person or another entity. The movement of funds through different hands is essential to the concealment of crime, especially the crime of money laundering, and the successful manipulation of its benefits. Multiple orders are necessary as a deterrent, not only to the principal actors in the criminal activity, but also those who facilitated such concealment and manipulation. So what Sheikh left the door open to is you can in fact recover benefits that passed from one accused and then went into the hands of the next accused. You can recover the value of that benefit from both those accused, which makes it even more controversial. But it has been approved by the Constitutional Court. So the definition of benefit refers to proceeds of crime. And so just to complete the picture, any property or any service, advantage, benefit, or reward derived, received, or attained directly or indirectly at any time in connection with or as a result of any unlawful activity carried out by any person, and includes property representing such property. So what the courts have said of this definition is the aim of the legislature was to cast the net as widely as possible, which means it should be very difficult for a presiding officer to say there was no benefit here. But once a benefit has been found, the presiding officer has the discretion to decide, well, what is a just order to make in the circumstances? Okay. I'm worried that we're running a bit out of time. So I think I can cover some of the additional topics as we answer the questions. But I just wanted to leave you with this concept before we open up for questions. Is sections 18 and 26 of the Act form part of a scheme, right, which is designed to enable the state to divest criminals of the proceeds of their criminal activities. And section 18 inquiries is essentially concerned with this. Shall I stop there and then open up for questions? And I'll be sure to cover the last few slides in answering the questions. I just want to get a sense of the extent to which you've encountered these inquiries and, you know, what, if any, challenges they threw up.
Sure. Thank you, Advocate Cronje. We'll open it up for any questions. You can just simply unmute yourself, raise your hand, and you can take it from there.
Maybe it's Jackie Wessels here from Limpopo. One of the issues that we find is because of the fact that this is a civil application that needs to be lodged before you're actually sentenced. I know that once or twice it happened that they tried to bring it afterwards, after the case was finalized. So maybe your thoughts on that. But I think the Act is quite clear about when it must be lodged or launched. Then the issue we often encounter is as to the papers itself, because I mean, it's an application, it's brought on affidavit, and this is an application that to an extent is not, it is as a result of the conviction, but because it's an application, the essential facts the application is based on need to be included in there. And a lot of the issues usually arise at how did they get to what the benefit would be. How do you determine that amount? So maybe some thoughts on that, because I think our biggest problem often is with the way the applications are dealt with or done. Thank you.
Yep, thank you very much. Both of these are very useful. So about the timing of the application, the Act is clear that it has to happen after conviction, but before sentencing. But there are circumstances where the presiding officer may elect to postpone the inquiry to after sentencing. So the issue is that the application must be launched and the inquiry initiated immediately after sentence, but it doesn't have to be concluded before sentence is handed down. And I mean, it's novel, these proceedings, even after 25 years. And it's still fairly novel around the world, because presiding officers will have been part of a trial where the evidence was led, and it would be entirely focused on determining the guilt or innocence of the accused in the commission of the crime. And you've done that whole exercise has now been completed, and a conviction is the conclusion reached. Now the prosecution launches a whole new inquiry into what benefit was derived not just from the offense that we just had a trial about, but related criminal activity. Is this a case where you can invoke presumptions to say this person appears to have wealth way in excess of what they can justify from legitimate sources of income? So do we need to consider that a confiscation order beyond the benefits just from the convicted offense? These are fairly weighty and complex issues. And so often a presiding officer wants to get to the question of sentencing and get that out of the way. And then you find that there's this long and protracted inquiry now that's going to be entertained. So there is a discretion on the part of the presiding officer to postpone to after sentence. And often, and technically, as I said in the beginning, sentencing is about what is the appropriate punishment. Confiscation is not supposed to be about punishment. So there's no reason in principle or in theory that you can't have sentencing and then proceed with a confiscation inquiry. But it's often easier said than done. But I have been involved in confiscation inquiries that happened before sentence and some after sentence. So the law allows it to happen after sentence, but it must be initiated. It cannot be initiated after sentencing, because then the ship has sailed for the prosecution. But the presiding officer can elect to postpone. The second question.
Sorry.
Yes.
No, I just wanted to make a comment, actually, and that is that I previously dealt with an asset forfeiture in a application in an abalone matter. And my experience was, and I thought that the Act provides that as soon as, or just after conviction, you can actually apply for the asset forfeiture before sentencing. But I just heard that you, pardon?
That is what the law requires. The law requires that the application must be initiated after conviction, but before sentence. But once initiated, it can be postponed even to after sentencing. So it doesn't have to be concluded before sentencing, but it must be initiated before sentencing.
Okay, cool. Thank you.
The second question, though, is how are these proceedings supposed to work? So Section 18 requires the prosecution to file an affidavit in which they address the two questions that the court has to make a determination on. The first question being, what was the value? Was there a benefit? And the second question is, what was the value of the benefit? And then the defense or the accused is to file an affidavit and has to engage with the averments so much as you would have in ordinary civil proceedings. You have the allegations in a founding affidavit, and then you have a response in the answering affidavit. And so every allegation in the founding affidavit that is not disputed in the defendant's affidavit is accepted. And where a dispute is raised in the affidavit of the accused, now the court has to make a determination of which version to believe. I hesitate to call these proceedings civil proceedings. They are civil proceedings to the extent that the standard of proof is a balance of probabilities. But unlike, and certainly unlike criminal proceedings, the presiding officer has a far more inquisitorial role. In fact, it's called the Section 18 inquiry. So the job of the presiding officer, is that another question? Jane Ngobeni, are you asking a question? No. The job of the presiding officer is to make this determination, exercise the discretion to hold the inquiry because the presiding officer finds a benefit has been derived, and then to make a determination as to the value of the benefit and the value of the order, the confiscation order that is going to be made. And essentially, the presiding officer must ask for the evidence needed to make this inquiry. So if the prosecution alleges that the accused is an abalone smuggler or a drug dealer, and they have derived a benefit from drug dealing to X amount, and that amount is made up primarily from what the accused has available in assets right now, for which there is no legitimate income to justify. If the defense doesn't engage with those allegations, the presiding officer is at large to conduct an inquiry and actually get to the bottom of. So instead of this passive role that or not passive role, but this removed, not descending into the arena role, here the presiding officer is in fact enjoined to get the parties to present evidence on the issues that the presiding officer has to make findings. So it requires of presiding officers to assume a different function to the function they perform when conducting the trial or when presiding over the trial. And I think that's an important distinction that many presiding officers aren't prepared for, because that's not the role that is required of them. I see there's another question while I pull up the section that gives the presiding officers this more inquisitorial responsibility. Lani Opperman.
Yes, Lani Opperman. Yes. What if there is a severe dispute of facts on the papers? Do you lead oral evidence? Do you go into a hearing?
You ask for oral evidence to be presented. I just want to try and project the provision in the Act that deals with it, because there are, of course, going to be disputes of fact, and the presiding officer can call for the kinds of evidence the presiding officer believes will resolve the dispute of fact. Often they're not. Often they're not willing to. So often the accused is still hoping to dispute all the issues that were resolved at trial on appeal. So they're not willing to engage with what the prosecution puts before them. And then the presiding officer must make a call. You know, you've given the person the opportunity to present evidence on an important fact. They've refused or elected not to, and so the presiding officer must then make a reasoned call and determine the issues.
Then just in the Uber case, was the accused convicted of theft from his employer?
Yes, he was.
Was that in another case or in the same case?
So I'm not that familiar with the facts of this case, but what I can do is let you have the judgment, and then
I'll get it. Don't worry. I was just wondering. Yes.
I'm sorry, it's been a while. I'm just trying to find the sections that I want to present them here.
We have another question, Hermione.
Sure. Let's go ahead.
Sure, Fezile. Fezile, you can ask your question.
That's my question. I'm here from the Western Cape.
Mhm.
I need to know the applicant's affidavit. May the is it telling the prosecutor was prosecuting the case? Is he supposed to file the affidavit himself or herself, or another prosecutor who's not involved in the case? Thank you.
Thanks for that question. I think it's I'm going to try and project the act. So I have to stop sharing and start sharing again. But if you read section 18 of the act, yeah, can you see the act?
No, you just yeah, we can see it now.
Okay, great. So I just want to show you that so sorry, just to the initial discussion we had, 18.3 is a court convicting a defendant may, when passing sentence, indicate it will hold an inquiry contemplated in subsection 1, which is a section 18 inquiry, at a later stage, if it is satisfied that such an inquiry will unreasonably delay the proceedings in the sentencing, and 2, the prosecutor applies to the court to first sentence the defendant, and the court is satisfied that it is reasonable and justifiable to do so in the circumstances. So again, the court is asked to exercise the discretion there as to whether it would be in the interest of justice to first have the sentencing and then have the inquiry. Then no application referred to in subsection 1 shall be made without the written authority of the national director. So anyone, the prosecutor initiating the application, needs to authorize the particular prosecutor to do so. And then to answer the question we just received, a court before which proceedings under this section are pending may, So the court may, in considering an application, may refer to evidence that was laid at the trial, right? So mero moto, the court can refer to evidence laid at the trial. Here's such further oral evidence as the court may deem fit. So the court can say, well, I want to hear from, and this is what courts often do, from the spouse of the accused, who seem to be living in the property that was bought with the proceeds of crime, to see if it's reasonable to order confiscation in a certain amount, because it's going to mean that if the confiscation order is executed, the wife will be without a place to live. You know, the court can ask, therefore, that oral evidence be laid, and the court can direct the public prosecutor to tender to the court a statement referred to in 21(1)(a). So the question is, should it be the prosecutor making that statement? Obviously, ideally, it should be an investigating officer or even another prosecutor, but ideally not the prosecutor who's prosecuting the application. But what there isn't is that it has to be the prosecutor who's bringing the application has to file the affidavit. But the prosecutor tenders the statement. The statement doesn't have to be in the name of the prosecutor. Usually it'll be in the name of the investigating officer. So, you know, I wanted to highlight the section 4 and 5, 5 in particular, because for me that is what I use to justify my contention that the presiding officer is given actually a fairly wide discretion. I'm sorry, I see there are 2 more hands, so perhaps we should take them quickly. Rosie Kumasamba.
Hello, good evening. I just wanted to ask, in terms of cases where you have assets or cases where, say, the money that's been used as a benefit of the crime is no longer traceable, how does the act or the prosecution or even the judge rule on such cases?
So your question is pretty much like the 2 examples I gave, like the accused stole money and then spent the money and claims that it's no longer available, or can even prove that she spent the money on gambling. Is that the question?
It's more so when like the defendant has gone through a process of like making sure that the money is disguised so that you actually cannot trace it anymore. So it's not conclusive whether or not they've actually used it for anything.
So it brings us back to being focused on what is the inquiry. The inquiry is, did they derive a benefit? So did a benefit accrue to them through the commission of the crime? It's not a requirement that the state proves that the presiding officer has to determine where the money ended up, because in the Joubert case, for example, the state accepted that the money ended up with another criminal, that it was no longer in the possession of or under the control of the accused before court, against whom a confiscation order was being requested. The courts have been very clear. The relevant inquiry is, did they receive it, derive it, or retain it at some point? The question is not, do they still have it? That is an inquiry relevant to a Chapter 6 inquiry, because there you actually have to have the assets that was derived or received. But in a Chapter 5 inquiry, you don't have to bring the assets before court, and you certainly don't have to demonstrate where the asset ended up, because often that is not easy to do. The relevant inquiry is, did the accused have control over the benefit, and did the accused elect to move it on, or to spend it in some way, or to pass it on to somebody else? Or even if somebody stole it from the accused, it was under the control of the accused for a while. So the accused certainly derived a benefit, however temporary. The next question then is, if it was stolen, would it be fair in those circumstances to make a confiscation order? Because remember, the purpose of the confiscation order is to determine, to deprive the criminal of the benefit. If the criminal has already been deprived from the benefit, not through his own or her own conduct, should the presiding officer still make a confiscation order in that amount? And that's a question for the presiding officer to determine, with justification. And I would argue that if the benefit's been stolen, you'd be hard pressed to say he should pay it back. But there may be circumstances in which that is appropriate. But remember, the two inquiries of punishment is separate from making an order for the benefit. So Pandelani Mudau, so I'm going to have to go much quicker now, and Lani Opperman, perhaps you ask your questions together and then we'll try and wrap up, because I think I'm over extending the time. So Pandelani Mudau. You are on mute, so you have to unmute. I've tried the whole presentation to get people to mute, and now I want you to unmute. Shall we ask Lani Opperman to go while Pandelani tries to work out?
Thank you. Thank you, Hermione. What I wanted to know is, just as in the instances of minimum sentences, common purpose, when the trial starts and the presiding officer has to inform the accused of these procedures, is it expected of the presiding officer to warn the accused that an inquiry will be held in terms of Section 18?
Well, a presiding officer can only know whether an inquiry will be held if there's a conviction. And then it's dependent on whether the national director has given a prosecutor authority to bring an application. So I would say the earliest opportunity there is any obligation on the presiding officer to inform the accused, who at this point now is a convicted person, is no longer an accused person, is when such an application is launched. And the presiding officer is the one who authorizes the holding of the inquiry. So the prosecutor says, I have authority to ask for an inquiry to be held. The presiding officer will have to hear from both sides. Do the jurisdictional requirements for holding such an inquiry, are they present? And those are really, has the accused been convicted? And has the accused been convicted of an offense from which he derived a benefit? And once those are answered in the affirmative, can there be an inquiry into the value of the benefit? And so the presiding officer will certainly have to explain to an unrepresented accused, I imagine, that these are the allegations that the state is making, that you were convicted of this offense and you derived a benefit, and they are asking me to inquire into what is the value of that benefit. They will make submissions on and present evidence on what they believe to be the value. You will have an opportunity to rebut that evidence, and I will, at the end of the day, make a determination, whether you derived the benefit, what the value of that benefit was, and what an appropriate order is, and you will make representations. You will have an opportunity to make representations on all those questions.
So in practice, do you know when you enter into the trial before plea that you are going to make the application?
You can't know that in advance, because you can't know what you're going to, if you are going to convict, and what you're going to convict of. And that's sort of, you know, often it's frustrating for everybody, because there's little to no warning that after a long and protracted trial, you can now end up going into another long and protracted inquiry about whether this person derived the benefits. In other jurisdictions, in the US, for example, you can't get a confiscation order unless you've laid out the basis for it in the indictment. But our system is different. And so not only can the accused will often be surprised. The only way they won't be surprised is if a restraint order was obtained. And in South Africa, we have many restraint orders in advance of the trial even starting, but those are initiated in the High Court. And so where there's a restraint order already in place, the accused will know that a confiscation inquiry is coming. But if the state hasn't brought a restraint application, it really is only once a conviction, once the court has convicted the accused, that the prosecution can get authority to initiate an inquiry, and the court makes a determination as to whether there's going to be one or not.
Yes, we will have to, it might move to constitutionality in the end. But there hasn't been a case like that.
About whether it's a surprise or not, or what are the obligations?
Yes.
Yeah, I think there hasn't, but there has been lots of constitutional questions around, you know, what is the nature of the inquiry, or even the role of the presiding officer. I can send you some, I think we'll send a package of some of the judgments that have dealt with some of these issues. I think I'm going to try Pandelani again, and then Rajendri Naidu. So Pandelani, can we try again? Perhaps if you can write the question in the notes, and then Vuyani, perhaps you can read it out. And then Rajendri, you can go in. Sorry?
That can work. They can write the questions and I'll just read them out to you. Just a quick reminder, we have 8 minutes of this session left.
Okay, so let's have Rajendri go, and then we'll have Pandelani Mudau write his question in the comment section.
So good evening, Advocate Cronje. I'm still with the AFU, but in KZN, we are running a project for the last 2 years, and we're predominantly concentrating on the Section 18, which I'm in charge of. And it's going well so far, but certain of the judicial officers are still, as we said, you know, grappling with the definition of benefit. And as you correctly put, it's widely interpreted to cast everything in the net, but obviously you first have to determine if there is a benefit, and that's just, is it a yes or a no answer? Now, there's a certain types of crime, which is, we see there's an influx in KZN, and one of them is copper cable theft. Now, when you go and steal copper cables from the railways or property, you're damaging somebody's property, or you're damaging the state's property. And even though the benefit, so-called the copper cable, is recovered, it still doesn't put the state in a position that it was to go and replace that, the costs involved there. Firstly, can we just inform the judicial officers, the theft of copper cable, is it a benefit? If a person has been convicted with a Section 36 theft of copper cable, is that a benefit?
So you see, this is an enthusiastic asset forfeiture prosecutor. Like I said, the purpose of asset recovery, right, is to deprive the accused of the benefit. it's not to punish the accused, but it's also not to fix all the state's problems, right? So of course, lots of damage can be caused by crime well beyond the small benefit that was derived from the offense by the individual accused. I mean, a carjacking is a good example. You know, you steal one car, but you actually create a lot of fear and uncertainty, and insurance prices for everybody goes up. You're not going to be able to get a presiding officer in that one case to say, and by the way, that's such a serious offense and it has such wide economic terrible consequences. I'm going to make a confiscation order in X amount. The presiding officer is looking at this particular accused. Some of the things you mention are factors relevant to sentencing, which is why I was saying earlier, although these two issues are separate, right? What goes into sentencing, you're all very familiar with. What goes into a confiscation inquiry is a lot stricter. Did they make a benefit? And what is the value of that benefit that the court should order should be removed? And it's a very tricky question, because you can set that benefit amount at something that can feel very punitive. And I urge you to read the Sheikh case, because in Sheikh's case, I'll give you this quick example. One of the things that is included in a benefit inquiry is the receipts. So everything you get from the commission of an offense. Let's say you're a drug dealer, and you had to pay for your precursors. You even had to pay for transport, right, to have the drugs brought. The state will say, you sold X amount of drugs, the market value of that drugs was Y. We believe the value of the benefit is what you made on the market, on the black market. The accused will come and say, and accused in cases around the world come back and say, but you can't just have the receipts, you have to deduct my expenses, right? And when you start doing that, do you deduct the hit on a competitor because you needed to deal with the competitor stealing away business? What the Constitutional Court said about deducting expenses is that we're not in that business. And what we are concerned with here is ensuring that the accused doesn't derive a benefit. It's a blunt instrument. So it does mean in certain circumstances, the accused will be a little bit out of pocket. But the purpose is not to punish the accused. The purpose is to put the accused back in the position that he would have been in. And it actually is open to the presiding officer to consider this question, to just give you an idea of how difficult the issue can be. Is in corruption cases, if somebody paid a bribe to obtain a contract, but they delivered the services, they built the school, and it's a high quality school, but is the benefit they derive from that crime the full contract price that the state paid for the school, or is it the full price that the state paid minus the value of the school that was delivered? These are the questions that a presiding officer, in the circumstances of a case as it is presented, must make a call. And the overriding question has to be not punishing this person, because that's the consideration for sentencing, but how do we ensure that the accused does not derive any benefit from the offense, and does not retain any benefit derived from the commission of the offense? So I mean, I hope that there's a whole can of worms on some of those questions, but
Advocate Cronje, yeah, just on that point, okay, so what if, I know you say it's an AFU enthusiastic person, but where they consent, the accused attorney legal representation consent that their client's benefit was 20,000 Rand to that. There's no need to go in an inquiry, we consent, we know we've damaged the infrastructure.
Well, I mean, I wouldn't characterize it as damage because, you know, there are civil proceedings where the state can recover damage for wrongs. It's delict, right? What Chapter 5 is concerned with is you committed a crime for profit or for benefit, and we want to remove that benefit. So if the accused comes along and says, I accept that I stole 20,000 Rands worth of copper, that's the end of the inquiry. You know, the value of the benefit to me of that copper was 20,000 Rand, take your 20,000 Rand. Then I see no difficulty. The minute you characterize it as this is representative of the damage that was caused, that may be causing you problems on appeal because that's
No,
not
that's perfect. I also agree. The very proceeds of the crime would be
20,000.
copper cable.
End of story. Yes.
Thank you, Advocate Cronje.
Cronje, we have two questions on the chat box. The first one is, would a benefit include the fruits of the benefits? For example, if the accused steals 1 million Rand and purchases property to the amount and leases it out, would the rental income be included in the definition of a benefit?
Yes, I think the definition includes profits. So profits is an easier question. Again, these things can all get trickier because where it can get tricky is the accused steals 1 million Rand and shares some of the benefit with his sibling who just graduated in investment banking, and he uses that money to make fantastic profits. Can the presiding officer say that a consequence of this crime, an indirect benefit, is however many millions the brother made with his investment? So again, that's why the Act gives the presiding officer the discretion to look at all the circumstances and make an order that is fair in all the circumstances. I don't want to be that presiding officer who has to decide how much of the benefit the brother derived using the stolen money to invest wisely and honestly must be returned to the state. But that would be what the inquiry would demand of the presiding officer.
We have another one. It's the question is, question or comment rather.
Yes.
Sorry. May I suggest that Chapter 5 and 6 be explained to an accused before plea, even during pre-trial, as been done with minimum sentences, where the charge falls under the Minimum Sentences Act, but the accused is found guilty of a competent verdict. In other words, it is covered and the accused knows that.
Yes, I think that that's actually a very helpful suggestion. There would have to be quite a few ifs and buts in the explanation, but I imagine it could go something like, if you are convicted of these offenses, the state may bring an application for an inquiry into whether you've derived a benefit, and a court may find that you have so benefited, and the court may make an order to the value of that benefit. Yeah, I think that probably would put everybody on notice and actually exercise everybody's mind that this is what we should be thinking about and considering as the trial is progressing. I think that is indeed a very good suggestion. A fantastic way perhaps to end off, because I think it imposes a responsibility on everybody, the presiding officer and the prosecution and the defense, to all be thinking about this question of whether the accused did this for some financial benefit or some economic benefit, and did that benefit actually accrue, and how much of it must we claw back? So I think, does that cover all the questions?
It covers all the questions in the chat box, unless we try to attempt to ask Mr. Mudau to unmute himself.
Mr. Mudau, you have to give us a thumbs up or down to say if we can proceed. I think we're giving up.
Yeah.
Sadly.
Yeah. I think we can,
But help.
I think we can close the session.
Mr. Mudau, I'd be very happy to answer your question if you emailed it to me.
Thank you everyone for attending the session. It is greatly appreciated. We understand that you lead very busy lives in your courtrooms, but then also like to extend a special thank you to Advocate Cronje for taking out her time to take us through Section 18 confiscation orders. I found the presentation very useful. I'm not a presiding officer, but then I definitely will ask, what is the benefit here? Thank you, everyone, and I hope you enjoy your evening.
Thank you, everybody, and thank you so much, Advocate Cronje. Much appreciated.
Pleasure. Thank you. I look forward to many more Chapter 18 orders going forward.
Thank you.
Bye.
Bye.